the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Judge Milkey. To my right is Judge Blake. To my left is Judge Sachs. And together we are your panel on the 4 additional cases we are hearing this morning. We heard one on Zoom already, and one has been pushed to October. We want to assure all the parties that we have read the briefs and the record. We are familiar with the facts and your arguments. And I say this because, generally speaking, 15 minutes per side is not a great deal of time, so we urge you to cut to the chase to the extent possible. On the other hand, if you have said your piece, there's no shame in sitting down. As one of my former colleagues used to say, if you hit a home run, there's no reason to run the bases twice. And with that, we will call the first case of the morning, Commonwealth versus DePina, 2022 P. 868. Counsel.
Good morning, Your Honors. Attorney Dana Gravina on behalf of Mr. DePina. We're here regarding the denial of a motion for new trial that Mr. DePina filed, in which he alleged numerous instances of ineffective assistance of counsel. The first of which concerned the fact that the complaining witness in this case was referred to as the victim 16 times.
Can I ask you some preliminary questions? We know what you've raised as issues, but it's accurate that a different panel of this court has affirmed his convictions, right, in a Rule 23, and that these issues were not raised at that time.
That is correct.
And is it accurate that I only have an affidavit from you, not from trial counsel or first appellate counsel?
That is correct.
Okay. Is there anything in the record about counsel being asked for one and denying the request, or is the record just silent on that?
The record is silent on that. And I would state there really is nothing here that appellate counsel or trial counsel could have said in an affidavit that would affect the court's analysis.
But our case law suggests that we can draw an inference from the lack of the affidavits, right?
The case law does say that you can draw an inference from the lack of affidavits, but our contention is that the ineffective assistance of counsel here is so complete and obvious from the trial record that there is nothing that appellate counsel or trial counsel, in other words, there's no strategic reason for trial counsel not to have objected. There's no strategic reason for appellate counsel not to have included these issues. So
And the denial of the motion was a margin order. Was there a request for findings?
I believe there was a request for findings and there were none issued.
And the motion judge was not the same judge as the trial judge?
That is correct.
What about the first motion judge?
That is not the same judge either.
As the judge that issued the ruling here?
Correct.
Okay.
Counsel, just as a matter of fact, under your client's theory of what happened here, wasn't the woman in some sense a victim?
Under his version of what had occurred?
Severely injured when she jumped on your client's car?
In that scenario, in which she would have jumped on the car and fallen off, then I would say, no, she is not a victim. Those would be...
Well, she could be an accident victim.
But that is not... Jumping on someone's car is not an accident. I would consider that more along the lines of, almost a self-inflicted injury. I mean, to jump on a car as it's moving to try to stop it, one could expect that they are going to very likely be injured as a result of doing so, and that is what happened here. The question before the court was, or before the jury in this case, was she a victim of Mr. DePina hitting her with his car, or was she someone who, exactly as I just stated, chose to jump on the hood of a car to try to stop it from driving away and was injured as a result? And in that scenario, I would say she is not a victim. So I would say that was the question.
What should the prosecutor have called her, if anything? The injured party?
He could have called her the injured party. He could have called her the complaining witness.
Well, she's not the complaining witness, right? The police officer is. That's the person that swears out the complaint. We retired that word decades ago when it relates to victims of crime.
So she could have been referred to as the injured party. She could have been referred to by her name. But the court has made clear that to refer to someone as the victim, I mean, the victim is a very specific term that carries a specific meaning.
And isn't this the classic domestic violence case, at least from the prosecutor's theory, that this incident occurs, they're in a dating relationship, they're still in a dating relationship the day of trial, she drives to court with him that day, as I understand the transcript. They talk about the case. Her testimony pretty much parrots his theory of the case. So this, to me, suggests a classic imbalance of power. So with that, why isn't the prosecutor able to call her a victim?
Because it's not for the prosecutor to decide whether she's a victim or not. That's for the jury.
Didn't defense counsel use the word victim?
He did, which is clearly an instance of ineffective assistance of counsel. That's why there's no affidavit from trial counsel. I mean, what is trial counsel?
Well, you just told me there's nothing in the record that says it. You can't now tell me, can you, in good faith, that the reason you don't have an affidavit is because he used the word victim? Can't have it both ways.
What I'm saying is he's clearly there's no strategic reason for him to call her the victim. I mean, that's a clear error on his part. So I don't think an affidavit from him would add anything to that.
Well, let's assume I agree with you, it's error. What's the prejudice?
That the question before the jury was, is she the victim or not? And
Isn't the question whether they bought her story or not?
But again, referring to her over and over and over again as the victim makes it as if her story is untrue in the eyes of the
How many days
Commonwealth.
was the trial?
It was a one-day trial. That goes to the next, I mean, the calling of her as a victim goes along with the next error, which we've alleged that trial counsel.
May I just interrupt before we get to that next error? The judge endorsed the motion denied after evidentiary hearing. Was there an evidentiary hearing here?
There was no evidentiary hearing.
There was no evidentiary hearing?
There was just an argument
Okay.
from the parties.
I was puzzled by that notation because I didn't see what the hearing would have been about or any other evidence of it, but he says, in parentheses, evidentiary hearing at Record Appendix 36, so.
And again,
It's your motion, so you should know. If there wasn't, there wasn't.
correct. And again, there simply was nothing more to add beyond the record as to the ineffective assistance of counsel here. I mean, this is not a case where we're calling it to question strategic decisions. This is not a case where we're calling into question, failure to call witnesses or anything along those lines. I mean, this is just clear on the record instances of things that happened at this trial that should not have happened, and that there's no reason why any rational attorney would have wanted them to happen. They severely damaged Mr. DePina's defense, and so there was nothing more to add by way of evidence. And as I stated, the next issue, again, goes to this question of, is this person a victim? Is this person a victim of a domestic violence incident, or did she jump on the hood of the car? That was the question for the jury. And that is that one of the officers involved in this case gave improper expert opinion testimony. He testified that the marks on the girlfriend's shoe were caused by being dragged on the pavement, and that they contradicted Mr. DePina and the girlfriend's version of what had happened.
Now, if the witness had not made that argument, couldn't counsel have made that argument in closing? The evidence was there And why couldn't the prosecutor just connect the dots in terms of the scuffing?
Well, I would say there's no way that the prosecutor could have made that argument in closing. A scuff on a shoe can be caused by a number of different instances. It could have been caused prior to this incident.
And that's precisely what defense counsel cross-examined the detective on at trial.
Made that
Got
point.
the detective to say it could have happened at any time, essentially.
Correct. But beyond that, I mean, the cause of a scuff on a shoe, how that occurs, and whether or not that is consistent with being dragged versus being jumping on a car hood and falling off, that clearly requires expert testimony. I mean, that's not just because someone has a scuff on their shoe.
What's your best case? Do you have a scuff mark case?
Your Honor, I would be happy to provide the court with a letter.
No, that's not what the purpose of the letter is. In your brief, do you have a case that discusses that an expert is needed for scuff marks?
I do not in my brief, but I don't think that is in question. I mean,
The jury had the shoe, right? That went in without objection. You're not raising any issue with counsel not objecting to the shoe itself going into evidence, right?
no, the shoe is fine.
So the jurors could look at it.
Sure.
They could see the scuff marks.
Correct. But again, it's way beyond the ability of a lay witness, a lay person, to determine what the cause of a scuff.
Common sense to me that if someone is dragged on the hood of a car, whether it's her fault or the defendant's fault, it's not inconsistent for a reasonable person to think that a scuff mark could have been from dragging on the pavement. Why would you need an expert to say that?
Wouldn't a scuff also be able to be caused by a person jumping on the hood of a car?
Well,
and
isn't that what I
falling
just
off?
said, though? Regardless of how Ms. Oliveira, we'll use her name so we don't call her a victim again, however Ms. Oliveira got injured, couldn't a jury listen to the testimony of the police, of Ms. Oliveira, look at the shoe, and come to that conclusion that her foot dragged? Whether it was your client's fault or not, a dragging can cause a scuff mark.
But that's not what the testimony was. The testimony was that that scuff contradicted Mr. DePina and Ms. Oliveira's version of what had happened. That's the major issue here, is that the officer is saying, I'm looking at this scuff on this shoe, and I can tell from looking at that scuff on the shoe that this was not caused by her dragging her foot on the ground after she slid off the hood of the car that she jumped on as it was moving away. That's the officer's testimony, and that's what I'm saying. To give that type of an opinion that the scuff was caused by her being hit and dragged as opposed to her falling on the hood and her foot dragging when she...
The detective said, in response to the prosecutor's question of what observations did you make, this is at transcript 1, pages 175 and 176. The detective said, quote, that it's got a scuff down the side and some black markings on it. I see striations in it as well, end quote. He was then asked, were you able to make an opinion on the scuff marks? And the detective said, quote, it was like it was dragged across the pavement.
Correct, and then moments later he was asked, is it consistent with Mr. DePina's version of what occurred? And he said, no, it is not consistent, it contradicts.
If he had not asked and answered that question, if you stopped where I stopped,
Then there would-
permissible?
No problem.
Okay.
It's that next question that makes it an improper opinion, because now he's saying this, and that's clearly where an accident reconstruction expert would be needed in order to look at the shoe, look at the scene, and say, look at the scuff marks, and would then be able to say, no, this was not as a result of jumping on the hood of a car, sliding off, and a shoe dragging in that manner. This is, and I don't even know if an accident reconstruction expert could have given that opinion. I mean, that's a clearly improper opinion to say it contradicts.
You cited the,
Go ahead.
I'm sorry.
you cited the Franceschi case from this court in your brief about scuff marks. And although I was on the panel, I can't quite remember what the holding about scuff marks was. Can you refresh our memories about that? It was scuff marks on a shoe after what I believe was a fatal accident in Springfield, and whether that required expert testimony.
And, Your Honor, I'm sorry, I cannot address that. I don't recall the specifics of that case. I just know it supported the position.
We'll look it up. I wanted to ask about the scuff marks. If no expertise is required to give the testimony he gave, was it helpful to the jury in determining a fact in issue? Which is one of our requirements for lay opinion testimony.
So, again, I think that the issue here goes to his opinion that it contradicted the defendant's version of what happened. And I would state no, there's nothing there that would help the jury in terms of making their opinion. That's clearly an improper guiding of the jury's resolution of what happened here.
So the jury could determine for itself whether it thought the scuff mark was caused by him hitting her or her falling off the car and getting dragged, or whether it was from some other time, totally unrelated to this incident.
Great. I don't know that a jury looking at that shoe, just like I don't know that an officer looking at that shoe or a reconstruction expert looking at that shoe would be able to give an opinion of whether it contradicted or was consistent with any version of events. I think it was clearly a situation where there was a scuff on the shoe, and that's all you could draw from that issue.
Counsel, were you counsel in the earlier appeal?
No, I was not.
No, okay.
I know I'm out of time.
Was the first appellate counsel ineffective for not raising these issues in that appeal?
Absolutely, and I know I didn't get to my third argument, but again, I mean, those are clear instances of a prosecutor going way beyond the permissible bounds of argument. To tell the jury that even if they wanted to, if they had some doubt and wanted to exercise that doubt about Mr. DePina's guilt, that they couldn't do so, for the prosecutor to say we've proved this beyond a reasonable doubt, to say that the defendant's version is ridiculous, to say that the witnesses who testified the Commonwealth were telling the truth. I mean, those are all just clear instances of going way beyond the permissible bounds.
Counsel?
Yeah, just on the point of the reasonable doubt, even if you want to give them the benefit of the doubt, you can't. Of course, the Commonwealth's response is, well, the judge instructed on reasonable doubt, the standard, and we presume the jury followed the judge's instructions. What's your response to that?
I would say that general instruction is not enough to cure the prejudice that resulted here. I mean, the case law discusses this over and over again, that when the Commonwealth gets up and makes a closing, they have the backing of the state, the backing of the Commonwealth of Massachusetts. Their words carry significant weight. And here, for the prosecutor to make those statements in closing, I don't think the judge's instruction could cure the prejudice from that.
Okay. Thank you, counsel. We will hear from the Commonwealth.
Thank you.
Good morning, Your Honors. Stephen Nato on behalf of the Commonwealth. I'm standing in for today on behalf of, sorry.
We're just waiting on the light.
All right. Good morning, Your Honors. Stephen Nato on behalf of the Commonwealth. I'm standing in for Attorney Courtney Almeida, who wrote the brief in this appeal. Our position, of course, is that the motion for new trial was properly denied. Trial counsel was not ineffective. And appellate counsel was not ineffective for failing to raise those issues in the direct appeal. And I think that's because on this record it is clear that none of the asserted issues created a substantial risk of a miscarriage of justice.
So you don't contest that there was deficient performance in failing to object, at least to the use of the term victim and the officer's testimony about the scuff mark?
I'll address each of those in turn. As to victim, I think it's pretty clear under, for instance, Commonwealth versus Cadet, that the term victim should have been avoided. The best course, obviously, is to avoid that terminology entirely. However, of course, the holding of Cadet was that even the repeated reference to the victim as such did not require reversal under the substantial likelihood standard in that case. And here, of course, it was undisputed that this young woman, young girl, came into contact with the defendant's vehicle and that she suffered very serious injuries, a fractured skull, concussion, abrasions, so on and so forth, and that she suffered very serious injury as a result of that collision, regardless of whether it was an accident or intentional.
You didn't write the brief, but page 15, the brief says, referring to Ms. Oliveira as the victim could hardly have unfairly bolstered her credibility where she was claiming she had not been assaulted. I don't understand that.
I think it was just, it did not bolster improperly her testimony.
But it still could have affected the jury's view, where this was really a case about whether a crime was committed. And when we refer to someone as the victim in the context of a criminal trial, the most natural connotation of that, I would suggest, is victim of a crime. Not victim of her own bad judgment, or, I mean, if you clarify, if you add some words like she was a victim of her bad judgment, or she was a victim of something else, okay, but she was a victim,
Right,
which suggests a crime.
Those, I think, are all the concerns of why you avoid that terminology in a trial.
So in a case where it's really kind of an issue of credibility, does the jury believe the story told by the Ms. Oliveira and by the defendant to the officer about how she jumped on and then fell off, or does the jury believe and draw inferences from the Commonwealth's disinterested witnesses about what they heard, and does the jury infer from that his car hit her rather than her jumping on? Where there's no forensic evidence really that points one way or the other, couldn't something like referring to the Ms. Oliveira as the victim push the jury in the direction of, oh, a crime was committed here?
Mm-hmm. Well, I think, again, as Cadet indicates, the jury is presumed to have a certain measure of sophistication. I mean, they recognize the facts here that there's a serious injury involved. This is not a case where maybe the police showed up and she had redness on her cheek from an alleged slap across the face. You know what I mean?
Right, but if they have a certain level of sophistication, then why do we have the presumption, at least from Cadet and other cases, that we don't refer to the victim as a victim?
Because
if the jury could overlook that every time, then why do we bother to prohibit it?
Because I think in certain cases they cannot overlook it every time, and I think that's Commonwealth versus Montanino. I think the Texas case cited in the defense brief is another example where it kind of goes right to the heart of the case, or in the Texas case.
Why doesn't it go to the heart of this case, where the issue really was a crime committed? Not who committed it, but...
Because I think under the circumstances, again, the jury recognizes that you're dealing with a girl who suffered a very serious injury.
Well, there are two very different versions of what happened. Would the jury have been surprised to know that the Commonwealth did not believe her version since they were prosecuting the case?
I think they would not have been surprised given the fact that she testified adverse to our theory of the case. And I also think if the jury, believed that she had somehow gotten away with this vehicle, that would not preclude a finding of recklessness on behalf of the defendant. The fact is, she didn't jump on a stopped car. She was injured by a collision with a moving car. And so even so, the defendant pretty clearly acted recklessly, I would suggest.
So could you turn to the scuff marks?
Yes.
Because, as you know, many people think in this CSI world, people are looking for forensic evidence to contradict testimony. And this is a case where, according to defense counsel, the witness said, you can tell from these scuff marks that their story of what happened is contradicted. How do you deal with that?
Well, I think the scuff marks in the case are a little bit of a red herring, because I don't think they bear on intent in any way, which is sort of the issue here, whether they came from the contact and being dragged by the car itself, or from him dragging her into the car after the fact.
And they were instructed on reckless and intentional, right?
Yes, okay. Yes. But there was no dispute that either of those two things happened. So wherever the scuff marks come from, I think there was a reasonable inference from one of those two, but that would not bear on intent in this case. That being said, I do think, while the initial part of the testimony from Detective Sorois that they appeared to be scuff marks from the pavement is a closed question, I think it's ultimately permissible in the circumstances. One issue with that, though, is I acknowledge does not appear to be the detective who arrived on scene and would have, seen the shoe as it lay and
Well,
could
let
have.
me ask you, because opposing counsel said the first two questions and answer that I read out would be okay. And then the third question that I think is the crux of his argument, it's again at transcript 175. The prosecutor asks, and Ms. Oliveira's shoe being dragged across the pavement wouldn't be consistent with what Mr. DePina had told you happened. Is that correct? And the officer answers, that's correct.
And, I mean, first of all, as we acknowledge in the brief, I think that's incorrect. And regardless of whether
So
it's
you say that's error but not prejudicial?
not
or not
prejudicial
substantial
and no
risk.
substantial risk of a miscarriage of justice.
But
and-
you have, in my mind, a classic domestic violence victim who I'm going to say is likely either afraid or being influenced in some way, and I mean, she has a fractured skull. This is not a slap to the face.
Right.
Not that that's okay either, but you have serious injuries here. The night of the incident, she says she can't remember, and then she testifies as she does. This seems to sort of answer the question, right, for the jury, that this officer is saying, you can't believe what he told you happened. It's inconsistent with what the shoe tells us. Is that permissible from a lay witness?
That part, I think not. Again, the large problem is it does seem to be arguably consistent with the defendant's version of events, but no reversible error for the reasons I described it. It's sort of a red herring because it doesn't bear on intent, and also the jury had the shoe. They could examine it themselves, draw their own conclusions. I think that where these scuff marks from perhaps the pavement is something a layperson could infer, depending on the circumstances.
So that even if the jury believed that she jumped on the car and that's how she got hurt, it would still be admissible to show that that was a reckless ABDW?
I think the conclusion about the scuff marks themselves being from the pavement or dragging or what have you would be admissible.
But you're saying in the totality of the circumstances, there's not a substantial risk?
Right. And again, in terms of the two reasons I mentioned, also, of course, defense counsel at the time attacked that assertion by Detective Royce through cross-examination, and Royce said he couldn't say for sure where that came from. So all told, I think the jury would give that. And there was no suggestion that Royce was there, that he had special knowledge. He did not claim to be an expert on scuff marks.
Are you familiar with the case that Justice Sachs raised with opposing counsel Franceschi or?
Not on that particular point, and so I apologize for that.
That's okay.
But, so turning from the scuff marks to the closing argument, beginning with the reasonable doubt issue, I acknowledge that the prosecutor's phrasing in that segment of her argument was at best inelegant, should have phrased that differently, but I think critically where that...
How should it have been phrased?
Sorry?
How should it have been phrased?
So where it comes, she's clearly transitioning from the theory of intent to recklessness. And she said up top, of course, I have to prove this case beyond a reasonable doubt. And then she goes into, here's why he is guilty of an intentional assault and battery with a dangerous weapon. And then it's kind of, as she's shifting, she says, but even if you have some doubt about that, he does not get off the hook because the evidence shows that it was wanton and reckless and so forth. And then that's the part of the argument she proceeds to. Phrasing that you can't give him the benefit of doubt, I think, should have not been said. But in context, in light of the judge's instructions on that particular point, and where there was no objection, likely everyone in the room probably understood it in that sense.
Well, unless counsel was ineffective. I mean, the principle is experienced defense counsel didn't object. That we can infer from that it didn't really have some tremendously emotional or shocking effect on the people in the courtroom, but that's not this case.
Sure, but even then, assuming that wasn't effective, or he should have objected, it would not have created a substantial, or not have constituted reversible error, so maybe he just thought, rather than,
Does his decision to bring her to a hotel or motel instead of the hospital play into any of these arguments?
I mean, I think that's kind of more of a factual issue that goes to, it, affects his credibility as to the strength of the case, and in light of that, whether any of these issues create a substantial risk of miscarriage of justice, where his behavior does not suggest his explanation is credible.
I don't know how this case is going to turn out, and again, for the second time, will tell you, I'm not going to shoot the messenger, but this seems like a perfectly teachable case to young trial ADAs. Having been one a million years ago, I can say, I hope that you will talk with the training folks in Bristol about how all of this could be avoided.
Yes, absolutely. And I, of course, acknowledge this is sort of an older case, and I hope our training has improved a bit since then.
That said, I should have asked your brother, but I assume he's out at this point, that he's not in custody.
Yes, I believe so. I'm not sure what prompted the more recent litigation.
So if you aggregate or accumulate the effect of the references to to Ms. Oliveira as a victim and the improper lay opinion testimony of the officer and the ADA's urging the jury to, put aside any doubt because, even if you want to give them the benefit of the doubt, you can't. Why don't those aggregate to sufficient prejudice or a substantial risk to warrant a new trial?
Well, because I think this was a very strong case for the Commonwealth, as Justice Blake sort of mentioned.
Very strong?
The defendant's conduct in the aftermath of the incident is not consistent with someone who accidentally strikes someone. To take her from in front of her home to a seedy motel in Dartmouth, that nothing about that lines up with the defendant's story. So given the state of the evidence in context, these errors separately together do not constitute reversible error.
Because of that?
I'm sorry?
Because he took her to the motel rather than a hospital?
Well,
I mean, other than that,
Or
what do we
to
have?
her home.
Right. We have the two disinterested witnesses called by the Commonwealth, and then we have Ms. Oliveira's version and the defendant's version as related to the officer. What is there to choose between those? Yes, we may have a gut reaction. We recognize this situation as one where the defendant likely spoke to the woman he injured and urged her to support his version at trial. But whether that happened in this particular case, we don't know, do we?
I think that's inferable from the circumstance that she said she didn't remember.
Well, it might be a permissible inference, but is it a necessary inference? Is it strong enough that we can say there's no substantial risk?
I think no, on this evidence, that's not a strong
Did she
inference.
testify? I went here with him today, we talked about the case, and I'm going to be driving home with him.
Well, she said we talked about the case. I came here today with him. We'll be going home with him.
And we're still in a relationship?
Yes,
Okay.
yes. And I think all those competing motivations were sort of in front of the jury. They were well instructed by the judge, and in this case, there was no reversible error. If there are no other further questions, that's my time. Thank you.
Thank you very much. The case is submitted. Our next case is Commonwealth versus Padilla, 2022 P505. Counsel, if you could just bend the mic toward you. Thank you.
Please the court, Adriana Condortese for the defendant appellant, Pastor Padilla, who contends that his trial was unfair and that he is entitled to a new fair trial. I am well aware that that it is a very tall order to ask the justices to reverse a conviction after a jury-waived trial. But in this case, I think it's warranted, and I have a few short things to say about that. The first thing is that one of the things I said was that there was no objection, so a substantial risk standard should be applied to the error. And I think that I was wrong, because when you reread the trial transcript, there was an objection, and the objection went specifically to this issue of percipient witness or drug expert police officer should not be able to testify to, what he said he saw when the arm went into the car. Right at...
Do you have a record cite for that?
Yes, I do, Your Honor. It's day one, page 26. So what happened is the DA asked, what did you see after he reached his hand into his pocket? And then defense counsel makes an objection. And what he's making an objection to is essentially the same thing that he lets slide in the next page. But when he makes that objection, the judge says, well, let's see how let's do it de bene, let's see how it goes. The next question...
So you're saying at line 14, when he's asked for the basis of his objection, and trial counsel says, from the distance Patrolman O'Hearn states he saw his hand go into the vehicle, it would be more consistent that his arm went into the vehicle just to be consistent with what's been said in the past. How is that an objection to the hand-to-hand transaction terminology?
Because what defense counsel is saying is, look, he said he saw his arm go in. It should be limited to let him saying that his arm should go in. So I think that is doing enough to make Judge Henry aware of what defense counsel's problem is. But then what happens
If your arm goes in, then how can your hand not go in?
Well,
Is he putting his elbow in the car?
No, I agree, but I think that defense counsel was making the point that he did not want the testimony about this very delicate area to be inconsistent. And then what happens is the DA specifically asks a question that objection went right to, and that invites the answer that the DA knew was the kind of answer that original objection would have been intended to avoid.
What's the answer that you say is improper? They slouch down to reach in and then quickly take his arm and hand out and reach back into his pocket.
And the DA says at page 28, well, what did you tell the officers you saw? And that is when Officer O'Hearn says, I told the officers that I saw a hand-to-hand.
Where is that on 28?
It's the very last line of 28 and then goes over to page 29. And that is really the unfair and entire problem in this case. And
So how do you account for the fact that then during cross-examination, the officer continued to use the phrase hand-to-hand, and the prosecutor objected, and the judge said, yeah, I know maybe in a jury trial we should stay away from this, but I can sort this out. I'm paraphrasing slightly because I'm not as good with the transcript as my colleague.
well, I did put that in the brief that, well, a judge in a bench trial is presumed to be able to instruct himself.
But here the judge was not only capable of doing it, the judge said, I'm sensitive to this issue.
Correct. But I think, going back to the substantial risk issue, I think that the correct standard of review that I think is really the appropriate standard of review to apply to this alleged error is phlebot. Can the justices be sure that the error did not influence the judge or had a very slight effect and that the substantial rights were not affected? When you think about the weakness of the rest of the evidence, I mean, so what? There was $150 in the guy's car when he got pulled over.
Which was the exact amount that the two people inside the house said they had just paid for the 3 grams of heroin that was found with them inside the house.
Right, these are 2 drug addicts who worked out a deal with the police. Okay, fine, but nevertheless, what I am saying is weak evidence, and we're finding was evidence that these 2 guys said it was exactly $150. To what degree did the fact finder's assessment of that evidence, which I'm saying is weak, and they had a huge motive to lie, and they couldn't even identify the defendant anyway, to what degree was the fact finder's assessment of that evidence colored by the fact that we hear a million times that there was a hand-to-hand? So that's the standard that I think should correctly be applied to this case.
I'm not convinced that it's preserved, but let's assume it's preserved and we're looking for prejudice. You said it when you started out. We're going right back to the fact that this is a bench trial.
Yes.
And I just looked at the comments that he made at the time. Seems pretty clear to me he understood what he was to consider and what he had to put out of his head. Yeah, you know, I'm struggling with the prejudice here.
Well,
Could
Going
the
back to the-
officer have described what he observed? And if he didn't subsequently call it a hand-to-hand, could the prosecutor have argued in closing that it was a hand-to-hand? I think that was sort of just.
well, the prosecutor, of course, and I suggest that what you saw, I suggest that what this evidence amounts to, which is the correct way to do it, right? I suggest that what this evidence amounts to, which I'm marshaling for you right now, fact finder, is that there was a hand-to-hand. And that's how we know, that's how case after case after case says that it should be done. And even later on in the trial, like in day 3, the DA asks one of the other police officers, you know, did you hear something from Officer O'Hearn that made you do something? Yes. Well, what was it that you heard? Well, no, what was it that you did? Well, I went to the house. Okay, that's explanatory. That's the kind of testimony that all the case law talks about when it says, you know, percipient witness testimony should be explanatory. Expert witness testimony, when they're a percipient witness, should be explanatory. It should not speak to the ultimate fact issue.
Wasn't the context of this, in fact, explanatory? Because the question that was asked was, what did you tell your colleagues? And that may be hearsay, that's a separate issue, but the answer was, I told him this. He's explaining how the police stop unfolded.
No, the hearsay, no, well, okay, but the hearsay is not, the hearsay is, in other cases have talked about this too. The hearsay is not the issue here. The issue is that they're asking specifically to tell, they're asking experts specifically what to say he said to another police officer. That was the ultimate fact. So the question is now.
How is that the ultimate fact? He didn't say it was, I saw a hand-to-hand of illegal narcotics.
I think we're ready to go in now. I think we have enough to go into the house. I think that that's the kind of, when the case law talks about explanatory, I don't think, and then there's a Lowry case that talks about all the different kinds of ways that indicate that, that indicate that somebody is in charge of a prostitute, is pimping a prostitute, that are explanatory, but don't go to the ultimate fact of, well, he's in control of her and he's her
The trial
pimp.
counsel did a very nice job with this evidence in closing. This is at volume 3, page 115, and he says, we heard testimony where a hand-to-hand transaction was observed by O'Hearn, and there were multiple inconsistent statements with what was actually observed. And he goes on for a good half a page about the evidence that he says is inconsistent with O'Hearn being able to see what it was that he claimed he saw. He did a great job of marshaling that evidence in his favor. He used it to his advantage.
Well, again, This is exactly the kind of error that if this had been a jury trial, it would be a huge problem. And it goes on and on and on, and there's always an argument at the end, well, did this really affect the fact finder? So if this correct standard is applied, which I think should be the Flaubert standard, the court must consider whether that powerful testimony, like in the first 5 minutes of the trial, that the police officer told his colleagues that he saw a hand-to-hand, did not color all the other evidence that Judge Henry heard as the fact finder in this trial.
Can I ask, if the officer had testified, I saw one of the DeMeo brothers come out, and I saw his hand go into the window, and he had some cash in his hand, and when his hand came back out of the car window, he had a glassine bag of white powder in his hand, and he stuffed it in his pocket.
Well,
and then you wouldn't have any problem with that?
No, then the Commonwealth has a terrific case.
So then, if the question were, and then, officer, what did you tell your colleagues? If he had said, I told them I'd seen a hand-to-hand, would you have a problem with that?
Well, I think that would be a case for a different day.
Well,
I would probably.
I'm asking you to answer the hypothetical. I understand it's not this case.
Yes, I would. Yes, I would. Because what I would, because then defense counsel would be able to, in closing or in cross-examination, elicit that, well, hey, maybe it was an empty plastic bag, and he was giving him a bag that he wanted him to take away and fill up at some later time. So maybe there was a drug deal in the works, but we don't know that there was one. That is the problem with this kind of I saw hand-to-hand, because it forecloses defense counsel's opportunity to present a defense, which is what makes this trial unfair.
Why can't defense counsel say, well, what do you mean you saw a hand-to-hand? What was exchanged? How could you see that from however many yards away you were? You never claim you saw any drugs going to Mr. DeMeo.
In the contents, yes.
Why did that testimony preclude cross-examination?
Well, I mean, I think if I was trial counsel, I probably wouldn't want to go there on cross-examination.
I'm sorry, I can't hear you.
That's probably some questions I would avoid on cross-examination if I were defense counsel, and just maybe arguing
Because
my
you're afraid
closing
of the answer.
argument. Yeah, well, right? Cross-examination is one of those things that you should not do too much of. I don't have anything else, and I'm happy to rest on my brief unless there's other questions.
Just one clarifying question on the motion to suppress.
Yes, Judge.
That motion was targeted essentially at the money, correct? The only other thing that I'm aware of was the
Identification.
cell phone.
Yes, it was.
Thank you, counsel. We will hear from the Commonwealth.
Thank you, Justices.
Punch.
Good morning. May it please the court. I'm Dylan Punch. I'm a student practitioner under SJC Rule 303, and I'm a 3L at Northeastern University. I'm under the supervision of Assistant District Attorney Jamie Michael Charles on behalf of Middlesex County for the Commonwealth. And the Commonwealth asks that this court both affirm Justice Fishman's denial of the defendant's motion to suppress the evidence because there was no error in his decision, and affirm the trial court's judgment because this single line of testimony did not create a substantial risk of a miscarriage of justice. And first and foremost, the Commonwealth's position is that the substantial risk standard is the correct standard in this case. The error was not preserved.
Does it really matter, though? Is the result the same?
Well, Your Honor, due to the overwhelming evidence at trial, if the standard was that the justices would be sure that that this testimony would not influence the judgment, the Commonwealth's position is that the result would have been the same. In this case, the defendant would only be entitled to relief if this court seriously doubts that the trial result would have been the same, absent this challenge testimony. And considering the strength of the evidence at trial, Your Honor, this includes the fact that this was a house that was under surveillance due to complaints of drug distributors arriving in the area daily, the most recent complaint of which occurred the week prior. The officers on scene were members of a drug task force and were surveilling this residence. While, they were aware that this residence was the home of two known drug users with whom the police had a history of interacting with. So while the officers are surveilling this residence, the defendant arrived on scene in a vehicle the officers recognized from previous narcotics investigations. Then, as soon as the defendant's vehicle pulled into the driveway of the residence, the occupants immediately exit the residence. They approach the vehicle. They have a very brief interaction. I believe it was less than a minute. Officer O'Hearn observed what he believed to be a hand-to-hand exchange that was consistent with the dealing of drugs. And while this...
Do you think that testimony would be admissible in a jury trial?
Yes, I do, Your Honor. It could have been worded a little bit...
If so, why did the prosecutor object when the witness kept using the term during cross-examination?
More likely than not, just to shore up the case, Your Honor. I believe that just to prevent these, allegations of impropriety in the testimony itself. However, this, as has been stated, the context of this testimony that the officer saw a hand-to-hand take place, he was actually responding to a question when he was asked what he relayed to the other officers on scene.
Why wasn't that hearsay, calling for hearsay?
It may have been hearsay, Your Honor. However, that issue was not raised, so I don't believe that's an issue on appeal right now. However, he did not opine on the ultimate issue. He never saw him sell drugs. He never saw a hand-to-hand exchange of drugs. And so this...
What is a hand-to-hand?
Well, a hand-to-hand exchange, the inference is that he observed a sale of drugs.
Cash, right?
Drugs and cash, correct, Your Honor. However, he didn't directly say anything that indicated that the defendant was guilty of this crime, as would be prohibited by the Canty cases. And he didn't say the defendant transferred something or, who handed drugs to whom. And certainly in this case, the Justice Henry, as the bench trial judge, was aware that the officers believed a sale of drugs occurred, so this really wasn't quite so prejudicial of an error. Now, after this observed hand-to-hand exchange, this is when the officers conducted a motor vehicle stop. They separated. Some of them went inside the house to talk to the drug users who actually purchased these drugs. And inside that residence, those two, they were brothers, admitted to purchasing $150 worth of heroin from the defendant. The officers recovered $150 worth of heroin from the residence, which was 3 grams, and then located $150 in the cup holder of the defendant's vehicle.
Was there any testimony about the street value of 3 grams?
Yes, there was, Your Honor. One of the purchasers, it's in the third volume of trial transcripts, did discuss the fact that 3 grams would be worth $150. Approximately, which lines up with all the evidence that was recovered.
Could you address, in the context of the motion to suppress, the argument with regard to staleness? Because you unsurprisingly make a big deal of the fact that the Commonwealth knew that the 2 people who approached the car were drug users, but that evidence was largely based on the overdose incident that was sometime within the last year. Why isn't that information stale?
Well, Your Honor, the information about the overdose, I believe that was July of 2014, and the arrest was in March of 2015. So that alone wouldn't be enough for reasonable suspicion. However, the officers were receiving complaints from members of the neighborhood of daily drug activity at this residence. The most recent of which, as I previously stated, was within a week of this arrest. And then they corroborated those complaints through this independent investigation, and which really addresses any issue of staleness. And the staleness cases, they tend to involve a delay between an affidavit and the execution of a search warrant, and then when the alleged crime was taken place. And even without that prior overdose, which was certainly a factor in this case, there would still be a reasonable suspicion to stop the car, just by virtue of the complaints of drug activity at this residence, coupled with the independent corroboration, Your Honor. If there are no further questions, the Commonwealth rests on its brief.
Hearing none, thank you very much. Congratulations on your argument.
Hopefully Judge Milkey didn't scare you.
The case is submitted. Our next case, our third out of four, is Porter v. Board of Appeal of the City of Boston, 2022 P974. Mr. Porter, the floor is yours. Now, could you begin by addressing the question of standing? And by that I don't mean standing originally in this case. I mean the standing in this appeal, specifically.
We're not on the record. We're not on the record. Here we go.
Okay. We are on the record now. If you could address the issue of standing in this appeal. The bond was purchased. You presumably paid money at that point to the company that issued the bond. This appeal is about the payout on the bond. Whether you win or lose this appeal, how does that affect you? Was it put any cash in your pocket or not?
I disagree. This appeal is about the amount awarded. So I appealed the amount awarded, okay? So the order to award this bond was after my appeal was filed. So the defense has obfuscated this and somewhat made it where it's about the order. It's not about the order, it's about the amount.
Okay, but let's say our decision affects that and says, oh, you're right, that amount shouldn't have been awarded. Does that mean money will be coming back to you?
Absolutely.
So did
How?
you put up the 25,000?
I did.
And the amount paid out was 23,900 and change. What happened to the balance? Did you get that back?
No, so I put up a bond. So the bond was for up to $25,000. Okay? At any point in time, the bond company could say, you know what, we don't want to deal with you. You need to put that money in cash. So whether it's a bond or it's a cash, it doesn't matter.
But did you put up yourself 25,000?
I put up a bond.
How much?
I put up a bond for $25,000.
How much did the bond cost you?
The bond cost me, I think, $500? I don't recall.
So that, for example, if we rule that you are right, the 23,900 goes back to the bond company.
Yeah, I guess it would.
That's what I think we're trying to understand.
Okay, I see what you're saying. And then they would reimburse me.
For what?
What, the 500?
No, they would reimburse me. I paid them. Okay, so the bond company paid you, paid the court, I paid them. So they called me and they said, hey, you need to make payment. You need to make full. So yes, I put up the $23,979.99.
So initially you put up the 500 to get the bond.
I put up the bond, the
And then when the
$25,000.
judge's order came out of 23,900 and change, they call you and say, Mr. Porter, we need the 23,979.
After the order,
Right,
yes.
so if we agree with you, the 500 you paid is gone, but the 23,900 would come back to you.
Ultimately, yes, it would come back to me, because whether the bond paid it or I paid it, it's my money. Ultimately, whether I pay you directly or the bond company pays you and I pay the bond company, it's my money.
But what wasn't clear to me, though, is when you said you paid 500 for the bond, it's not in the record that you paid the 500 in the first instance, and then the bond company required you to pay the 23,979.99. That's not in the record anywhere. That's, I think, why we're asking you.
Okay, I guess I understand that, the way that bonds work. You understand it probably better than I do. So the way the bonds work, obviously, whether it's whether it's, a bond for someone who's a criminal or what have you, somebody has to pay it when it comes due. And that person was criminal, or in my case, I had to pay it when it came due. So the bond company held the obligation, they paid the court, they came to me, and they made me pay them.
So if we look at what was in the original appendix, not what was filed after that. Where is the surety? Where is the relationship between you and the surety in the appendix?
In my appendix,
Yes.
that I don't know. I don't know that it's in there because my argument was not about the payment. My argument was about the amount.
No, I understand that, and
Yeah.
I've looked at your notice of appeal, and just so we're all clear, and this is from the docket in the Superior Court, you say you are appealing, quote, motion to allow in part payment of surety bond. So what I'm trying to figure out is what your legal relationship is between you and the surety. Because my understanding is when I read the bond, the surety has the sole discretion to pay out on the bond.
Indeed, but that's all based on the court's requirement to make a payment.
So is it up to the surety to go to the Superior Court and say, hey, we disagree with this 2397999? Who can challenge that amount?
I can.
How?
Because the ruling for the $23,000.
24.
Yeah, 24 was on me. That ruling was against me. So again, whether it was my cash sitting there or a surety bond, it's like maybe it's like car insurance. If I have car insurance, the insurance company has to pay it. If I'm at fault, then maybe I'd have to reimburse the company. If I don't have car insurance, I still have to pay it. The obligation is to the court. The monetary obligation is to the court. I fulfilled that obligation via a bond. I could have put it forth by putting all the money there.
But the motion was styled as for paying out on the bond.
Right.
So it was, in a sense, targeting the document that guaranteed this, as opposed to saying, you owe X amount in attorney's fees.
My
I mean,
initial...
this may not have been proper, but this is how the issue was posed to the Superior Court.
So so you're saying that my motion for appeal is not for the amount?
Well, I think I pulled the bond off the Superior Court website because neither of you gave it to us. And the bond says, so the bond company is called United Casualty. I'll just use that as a shorthand name. It says that Eric Porter is the principal, United Casualty is the surety, and that you, the principal and the surety, are jointly and severally bound to the Realty Association. They're the obligee for $25,000. And then it says that the Realty requested a bond with sureties to be filed for $25,000 pursuant to the Boston Zoning Enabling Act, and that a condition of the obligation is that if principal, which is you, shall prosecute the case with effect and indemnify and save harmless the Realty Association, in whose favor the zoning board decision was rendered, from damages and costs. So I think what I'm trying to figure out is if you and the United Casualty are jointly and severally bound to the realty company, do you have the right to pursue this? Did you have to bring in United to pursue this? It's a very technical question, I understand that.
Understood.
But I'm trying to figure out what your obligation is under the actual bond that you signed.
Yeah, again, I understand that sort of thought and argument, but what am I appealing? I'm appealing the decision to award money. which is before the,
Even if it was a penny, you say it was wrong to award money, period, stop.
yes. And that's the appeal that I have. Again, as a pro se, maybe I don't have the complete sort of, I'm able to look 100 yards down the field like you guys are. But what is my appeal? My appeal was immediate after the decision of that amount of money. That's what I'm appealing. The decision.
Do you think the realty was entitled to any amount of money, or do you think they were entitled to zero?
Well, in my presentation, in my brief, I'm saying, what I'm saying is, the appeals court denied the awarding of legal fees.
In the first appeal?
On May
Right.
5th, 2021, all right? You remanded it back to the Superior Court. The Superior Court got rid of construction fees. This is not signed, this is not evidence, we get rid of it. So now you're left with nothing. So how is the judge awarding legal fees?
So the statute that governs here, the Boston Zoning Board statute, says that the court in its discretion may require the filing of a bond to cover damages and costs, which the appellee essentially may sustain in case the decision of the board is affirmed. Damages and costs. And then a later provision in the statute says costs shall not be awarded absent a finding that the party acted in bad faith or with malice in appealing. So that's a limitation on the payment of costs. But the bond is supposed to cover not only costs, but damages as well. And I don't see a limitation there on payment of damages, that the court has to make any finding about bad faith, malice, or frivolousness before the court can order damages paid on the bond.
Forgive me, I disagree. In a recent case by the Supreme Court that was extricated from this court, Merengue versus the Board of Appeals, they actually go in extensive length about that.
Well, but that's under Chapter 40A, the Statewide Zoning Act, which only has a provision for bonds covering costs. This statute is different. It covers costs and damages.
But yeah, so what are we, how are we defining what damages are? Again, there's no evidence for damages, there's no evidence for legal fees.
Why can't attorney's fees be damages? Putting aside, assume just for the moment that an affidavit from an attorney saying, this is what I billed my client in order to defend this case. Assume, just stay with me for a sec, assume that that's competent evidence. So why does the amount of attorney's fees that the Fung and Shu Realty Associates incurred in defending this appeal not constitute damages?
Well, again, that Rule 602, federal and state, you can't have an attorney be a witness. He's either...
I'm asking you to assume for the moment that the attorney's affidavit is competent evidence, and these are accepted all the time in every court in the land, as far as I know, an attorney's affidavit as to the amounts billed. But just assume that that's true. Why can't attorney's fees fit into the statutory provision for paying damages out of the bond?
Well, again, I would have to turn to, the recent Merengue case. And again, you're saying damages. I get that. I haven't been able to sort of process that whole thought. Again, as a pro se, these nuanced words of damages in the Enabling Act versus...
Yeah, it would be nice if they'd specified what sorts of damages, but it's clearly something different than costs.
Again, I agree.
And the SJC in the Merengue case cited a number of cases where damages could include attorney's fees. It didn't resolve the issue, finally, of what damages includes, because it wasn't an issue in that case.
But I was going to call you counsel, isn't the better response to Judge Sachs's question that had the prior panel of this court awarded attorney's fees for a frivolous appeal, then the defendant could have gone back in Superior Court to collect on the bond for those damages. But that's not what happened here. In fact, the prior panel said this is not frivolous, and we're not going to assess appellate attorney's fees, and therefore the damages don't exist to collect against the bond.
Yeah, absolutely, I agree. We're looking at it sort of at the same thing. We're looking at the elephant at different angles. You said no legal fees. what's being applied is legal fees. So what does it matter whether it's the legal fees are sort of I mean, how are you going to reclassify legal fees as damage?
Do you understand that the 23.9 and change were the legal fees that the Realty Association said they incurred in the first appeal? Is that your understanding?
No, I believe that, I thought it was the legal fees for after, from the Superior Court to the appeals court. The appeals process is what I understood.
This appeal or the prior appeal?
The prior appeal is what I understood it for, because I think there was, you know, there was no bond prior to the Superior Court. So prior to the first appeal, there was no bond, so there was no legal fees. That's sort of a standard. You get to not have legal fees, you know, two parties fighting against each other. So, yeah, again, it's those again, also, those legal fees don't add up to anything. So where did she get this number?
Do you agree that the invoices from the lawyers exceeded 23.97999?
I don't. Again, to me, I looked at it and said, there's no evidence here. So.
But on the math, they at least seem to add up to more than 23,000 and change.
I mean, again, I guess, I saw it as not being evidentiary. I saw it as not being evidence because it's not signed. I mean, easily could have had receipts, deposit slips, something. We assume that the attorney didn't write these invoices, right? He probably didn't sit down and pound out. He works for a law firm. He didn't pound these out. So how does he know that they're correct? How can he testify to this? He didn't write the invoices.
I'm afraid your time is up, Mr. Porter. We'll hear from
Thank you.
The other side.
Good morning, Your Honor. If I may please the court, my name is Jose Centella. I'm with the law firm of Nathanson and Goldberg. Very happy to report that I've started this case after he appealed the ZBA back in the spring of 2017.
I'm very concerned about something. I just want to get to it at the very beginning. On page 21 of your brief, you reference something called a general indemnity agreement, and you cite a paragraph that would suggest that United Casualty has the exclusive right of whether or not to determine whether or not to pay a claim. And I was particularly interested in that, and as you know, the panel asked for the production of that because it was nowhere in the record. My understanding is that initially your response was, well, that's just a standard thing. I think it's fair to say that there is no such standard thing in the appeals court, but what you produced, at least as I understand it, was not applicable to this case. So your argument, because I have the surety bond and the surety agreement, and it's not what you gave us. So how can I rely on paragraph 7 of the general indemnity agreement, which, if it is in fact part of this case, seems to answer the question before us? I'm very troubled by that.
Because I can explain that, Your Honor. I did not have the copy. I did when I received the call on Friday from the clerks here multiple times. I dealt with the counsel for the surety company, and I immediately requested that he send me the actual copy of it. His response was, it's a standard language. If you go on the website, which is where I went to initially, and copy the standard language from the surety company website, and that's where I came up with that paragraph number.
Mr. Porter filed what's called the United Casualty Insurance Company License and Permit Application. It doesn't have a paragraph 7. The Superior Court has a bond, which is docketed at docket entry 42, that doesn't have a paragraph 7. There's nothing in this record here or at the Superior Court, which we can take judicial notice of, that says that this general indemnity agreement is part of this case.
It is not. It's a website that states that whenever a
So
surety...
what's our authority to consider something on a website?
Because of the language on his own document, which he did not respond to until late that Friday afternoon. I was still in the office.
On that, does it cross-reference
But
it?
it's similar to the language on the website, paragraph number 4. The company shall have the right to settle and compromise.
All right, so you agree that we should be using what Mr. Porter gave us in
100%
response
correct.
and not what you sent us, because that's not part of the case.
That is not
And
part...
therefore, that part of the brief, we should ignore, because we don't the general indemnity agreement is not part of this case.
That's correct. It's just that the law, and the law states that the surety, once a payment is made on a bond, the surety is subrogated as the owner of any claim to that funds. So that's the
What
cases.
case says that?
In my brief, in all of the cases that I have cited, Your Honor. So I wanted to find it a standard language. And when I spoke to Olson, David Olson is counsel for surety. He says, I will get you that on Friday, but it was kind of late. It was 11 o'clock. So I said, I want the actual contract.
I'm just so confused about how you can cite an indemnity agreement without a record cite and tell us that that's what's binding on us.
It's just as a starting point because of the language on his own surety bond. Paragraph number 4, I will read it for the court, that the company shall have the right to handle or settle any claim on a suit in good faith, which is the standard language in the cases that I've cited. That's the law of surety.
Right, but you would agree with me that that's different than what you say at page 21.
What I quoted, exactly. But the law is the same. The law states.
Can I just get clear on which way the money flowed here? Once the order that Mr. Porter has appealed from was issued to pay, we're calling it $24,000 in round numbers, who paid that money to your client?
The surety company made that payment.
And then your understanding is that they then call up Mr. Porter and say, hey, we had to pay $24,000 on the bond. You need to come pay us that money.
That part, I just learned that for the first time because of the question that you posed.
So you don't know whether, if Mr. Porter wins this appeal and we say there was no authority for the court to order that $24,000 to be paid, you don't know whether he would get any money back or not.
That's correct, because it's the first time that I heard that he had to reimburse the money. But that's not what he put.
But it's not surprising, is it, that the surety wants to get paid?
I didn't know if that's for instance, if they come back and have the right to, but under the website, they said they do have the discretion to come back in order reimbursement.
Vis-a-vis you.
Correct.
They get to make the call whether they pay on the surety. That makes a lot of sense. But it doesn't mean they can't then go after Mr. Porter.
In that indemnity, if you read the whole other paragraph, it states that they do have the discretion to go after the person who posted the bond. They do have the discretion to go after them. It does state that, even in the general indemnity. They have the discretion to go after, if they make payments, to go after and seek reimbursement. But the fact in this case here, nobody knows if, in fact, Mr. Porter has made any payments to the surety company. There is no evidence of that.
Is the 2021 decision of this court res judicata on the issue of whether or not the appeal was frivolous? And if not, why?
Absolutely. Let me go back. I wanted to put it in perspective, the history here. Case started in 2016. The ZBA granted the relief in 2017. He appealed for trial in Superior Court. The trial was not held until, I believe it was July 2-day trial before Judge Giles in 2019. After the 2-day trial, which he only testified, we put on 4 witnesses, and I was counsel of record at that. That's where I was engaged. After he filed numerous motions to come, delay. That's why, after that, Judge Giles made a findings. No standing. The decision was meticulous and was very specific as to the evidence that was presented, based on the 4 witnesses that we put on at the time of trial. And I asked the judge to not stop there, because we could have ended the trial. If he had no standing, then the court had no jurisdiction to continue. I said, I want to proceed with this because of his history. He has made 10 zoning appeals.
But the issue is, was the earlier appeal frivolous? And a panel of this court said, we are not going to award appellate attorney's fees. And Judge Blake's question is, why isn't that res judicata that the appeal was not frivolous?
Let me go answer that. So then the appeals court back in 2021 made a ruling and upheld the decision of the lower court. Then he appealed. I did not ask for a bond until he finished all his appeal. He applied to the SJC for further appellate review back in 2019. So after the SJC denied further appellate review, and then I asked that the money be posted and all of that and be released because of the completion of all the appeal. Then he filed a motion, after I filed a motion to disburse the funds, then the fund was disbursed. But let me address that. The judge had a hearing. My own affidavit that I filed was signed under oath and penalties of perjury.
Did Judge Giles award fees?
No, it went to Judge Mulligan. Judge Giles had
So
retired.
Judge Giles did not.
Judge Giles ordered the
Her
bond.
decision came here under 99 Mac 1123, and a panel of this court said, this is an appeal of Giles' decision, the defendant, which is your client, has requested an award of attorney's fees and costs, arguing that Porter's appeal is frivolous, citing Mass Rule of Appellate Procedure 16A10. We declined that request. So I want to re-ask my question. Why is that not res judicata on the issue of fees?
Because at that point, it was just a standard practice. When we did the brief, I ended with that specific request on all my briefs. We asked that under Mass.
Volumes of briefs that don't ask for that. It's not a standard request. You have to set out in your brief why. And if I recall, you cited Fabry v. Walton and all the cases having to do with a frivolous appeal. This court said we declined the request to award fees as the claim that the appeal was frivolous. I don't know why it doesn't stop there. I need you to help me understand that.
He has never raised that. That has been waived. So
Jurisdiction's not waivable.
I understand that. But at that time, my point is, the only issue before this court, and you could tell based on my brief that he was all over the place. He re-litigated and he re-argued the standard. He
I
re-argued.
looked at his notice of appeal, and Mr. Porter and I had a conversation about what was on appeal. I think we all know what's on appeal, which is the order of 23-97999. That's the amount of fees that you say you incurred for the Giles case and the Giles appeal. A panel of this court said fees denied, essentially. Isn't that res judicata?
That was back in the first appeal.
I agree.
But that was, at that point, there was no money. There was nothing that was done at that time. So
You asked for fees at that time, and a panel of this court, because you said that appeal from Giles was frivolous, and this court said no.
no award shall be awarded at that time.
Okay, let me ask you a question that may leap beyond that point. Do you agree that in order for the court to order payment to be made on the bond, there has to be some kind of finding that the appeal was frivolous or made in bad faith or with malice?
Yes, and that's the standard because of the chapter, section 11 of the Enabling Act entitles us to deter frivolous and meritorious appeals. When you read the summary before with them, that damages didn't constitute cost, was not applicable to malice and bad faith and all of that. So if you look at the factors at that time, the court did not hear any argument.
No, I'm getting confused by your answer. Do you agree that for any payment to be made on the bond, there must be a finding that the appeal was frivolous or in bad faith or made with malice? Or do you contend that that limitation applies only to paying costs on the bond?
Cost only, that's my point.
Okay.
So damages has no limitation under paragraph 1 of section
Okay.
11.
And do you contend that the attorney's fees here were damages?
Correct. And
And
that
what authority, what case would you cite for the proposition that the term...
same case that he cited that you reviewed, which didn't apply, but it says that damages can include all of this, legal fees and so forth. We do it all the time. And my point was that he contested my affidavit. It was me who filed the affidavit, and I did it on the pains and penalties.
So in your view, even if we accepted the prior appeals court panel's conclusion as binding, that his first appeal was not a frivolous appeal, or maybe even wasn't made in bad faith or with malice, that would not preclude the court, the Superior Court, from ordering payment on the bond? Is that your position?
That is correct, because the problem here is he has appealed 5 times. He didn't end when the SJC
I'm really
denied.
asking about what the law is, what Section 11 means, not what Mr. Porter may have done in this case or other cases. I just want to get the basis of your position that that an order to pay attorney's fees fits into the Section 11 provision for paying damages and doesn't require a finding of frivolousness or bad faith or malice?
No, because damage has no limitations under the first paragraph of Section 11. And we did produce some cases in my brief that under the first section or first paragraph of Section 11, there is no definition, there is no language, bad faith or malice in that first paragraph as to the definition of damages. There is no limitation, there is no restrictions. However, he is correct that under the second paragraph of the Section 11, when it comes to costs, and costs are different, that it has to be based on malice and bad faith.
So the 23,979, those were fees that represented what? What were those fees for?
Damages that I sought because
Damages for what?
my clients had incurred for the 5 appeals that have been done in this case. The total amount of bills at that time was about 50
So
cents.
was the 23,979 partly damages for the Judge Giles appeal?
Correct. It flowed from after that trial. That's what the judge limited. It was not Judge Giles, it's Judge Mulligan limited.
Well, Judge Mulligan issued the order, but what I'm
Correct.
trying to understand is, does the 23,979 represent work that you did in the Giles, the appeal of the Giles decision and the request for further appellate review?
That's correct. And it was a lot more than the $23,000 that she awarded because she said she was not awarding other parts. So she did review it very thoroughly and apply the standard under the factors that have to be applied, that to weigh the validity of his appeals and to weigh his ability, the resources for making payment, and whether or not this would prohibit or deter further appellate reviews and so forth. So those factors were considered by Judge Mulligan when that order was entered.
You have 6 seconds if you'd like to use it.
Judge, I wanted to start by saying that we've been here since 2017. He has filed 5 separate appeals, and I do see this going further. So the Enabling Act has a great statute here to deter a person like the plaintiff in this case from filing further appeal on this case and other appeals. He has filed 10 zoning appeals, more so than me.
Counsel, your
Thank you.
time is up. Thank you very much. The case is submitted. Our fourth and last case of the morning is 2022 P908, Perisho versus Stowe Board of Health.
Good morning. It's unrebutted from an expert hydrologist that the proposed septic system on the property would result in my client's drinking water wells. And then third, the Superior Court erroneously affirmed the septic system permit where there was unrefuted evidence from an expert hydrologist that the leaching field on the property would not comply with Title V's vertical separation requirement. So starting with the nuisance and trespass claims, the plaintiffs are direct abutters to a duplex unit in a duplex property in the town of Stowe, Massachusetts.
We've got the facts, so why don't you proceed right to what the standard is?
Great, thank you. The test is whether there are any uncertain or contingent events. And the judge in this case essentially ruled in his ruling allowing the motion to dismiss that the plaintiffs couldn't prove that because it hadn't started.
What case asks whether there are any uncertain or contingent events?
Well, the case actually cited by the defendants is very instructive. The Chatham Airport case that was cited in their brief, in my reply brief. In that case, plaintiffs brought a nuisance claim about a skydiving operation that may occur at the Chatham Airport, but no lease had been signed, no contract had been signed, there was no evidence of what the hours of operation would be for the skydiving operation, where it would happen. And so
Right.
the court said that was uncertain. In our case, it's the opposite. So in our case, there is no uncertainties and no contingencies.
Well, yes, the permit has been issued, and if we affirm it, then it's going to remain in effect. We haven't made that decision yet, but just because the permit is issued doesn't necessarily mean that a nuisance or trespass will occur on your client's property, does it? I mean, let's assume that the project is constructed as planned. How certain is it that any nitrogen pollution or contamination will reach your client's wells?
It's as certain as it can get. We had an expert
Well, it's not there yet.
I'm sorry?
There's no nitrogen being put into the leaching field yet.
Well, that's correct, but Your Honor, that's the case with a lot of cases that have been cited in my brief and by the Supreme Court and PG&E. You don't have to have the actual harm to begin in order to bring a claim for prospective damages.
Well, let me ask you this. I don't know if you're familiar with a case called Shaw versus Harding. It's a 306 Mass 441. But it's been followed in a number of recent cases. And it says, one is not required to wait until he's injured before he can apply to a court of equity for relief. But he is not entitled to seek relief unless the apprehended danger is so near as at least to be reasonably imminent.
Right.
So if we were to accept that standard, reasonably imminent, can you say that the threat to your client's wells is reasonably imminent?
Absolutely.
How many years from now will it be? Let's assume that today or tomorrow we issued a decision affirming the permit. How many years would it be before any pollution occurs?
As soon as the project starts, as soon as the project is built and occupied and toilets start flushing, that's when the nitrogen goes into the system, into the leaching field. That's when the groundwater is contaminated under the leaching field, and my client's wells are 110 feet downhill from the septic system.
How long does it take for the contaminated water to migrate from the leaching field or from under the leaching field?
I don't think we have the answer to that because we didn't have discovery in this case, so we weren't able to actually do test pits on the property to understand the rate of flow.
Okay, but is there any reason that you couldn't bring the same nuisance and trespass claims on the day the occupancy permit is issued and people start going into the project and flushing toilets? Would you be in any worse position then?
I suppose not, Your Honor, but the project would be because they would have spent hundreds of thousands of dollars
So
building
they
this
would be
project.
proceeding at their own risk?
I guess you could look at it that way, Your Honor. From a practical standpoint, that doesn't make sense because you'd have two families living in this property that you'd have to evict to remedy the solution. So that's why we brought this case as part of our appeal of the Title V permit, which we had to under statute of limitations.
I'm trying to figure out in an area so heavily regulated in terms of the Title V standards and so forth, why isn't the common law to at least some extent preempted or displaced? If they have a system that has been determined to meet all the Title V standards, how can you claim that that is a nuisance?
So, Your Honor, the Title V standards are insufficient in protecting my client's wells and are frankly insufficient for protecting public health. And one of the main arguments on annulling the Title V permit itself, count one, was that their argument was that the drinking water regulations that apply to public water systems and would apply to their well does not apply to our wells under Title V. If you strictly read Title V in the nitrogen loading guidelines, they say that any well on their project site can't be contaminated. The level of nitrogen cannot exceed 10 milligrams per liter, which is the state drinking water standard. So if you have a well on your property, you can't exceed 10 milligrams per liter. But if the well is on an adjacent property, the regulations don't apply. This is the logic of Title V, and that's why there's a problem. That's why we have to bring a nuisance and trespass case if we don't prevail in count one, which was the appeal from the septic permit.
Is there anything in the Title V regulations that say you cannot cause an exceedance of a drinking water standard?
There is, but only 2 wells on their property. So only when you have a well on the same property as the septic system, because that's considered to be a nitrogen load, a sensitive area. So there are nitrogen-sensitive regulations under Title V, 310 CMR 15, but that
Which do not apply.
that requirement that you just cited, Your Honor, only applies to wells that are on the same site as the septic system, or if you have other nitrogen-sensitive areas, which this property doesn't have. For example, if you have a Zone 2 for a public water supply, that restriction would also apply, but that's not the case here because everyone has private wells. Everyone in this neighborhood is served by private wells.
So that I understand the relationship between the counts, if we were to affirm the decision, hypothetically, so that your nuisance and trespass claims wouldn't go forward and the Title V permit is affirmed, they go ahead and build, and then, lo and behold, a couple of years from now, nitrogen pollution starts showing up at your client's wells. Do you have a remedy under Title V? Is there any kind of permit that you could ask to be revoked because the excess nitrogen is reaching your client's wells?
Not that I'm aware of, because they would argue that these requirements never applied under Title V. So we never had that protection under Title V. Our only remedy would be, according to them, our only remedy would be nuisance and trespass. I don't agree with that. I think Title V implies that you can't pollute your neighbor's well if you can't pollute your own well. It just doesn't make any sense. The overall public purpose of Title V is to promote the public health, is to protect public health in the environment, and to...
But this case is not like the Reynolds case, I suggest, because Reynolds was a 40B case about whether it was reasonable for the Stowe Board of Zoning Board of Appeals to waive a local requirement that was stricter than state requirements. And our court said, no, it was not reasonable as a matter of 40B law. This is purely a Title V case, at least count 1 is. Would you agree?
That's correct.
So we're not making the same kind of balancing of the interest in pure drinking water versus the need for affordable housing.
That's correct. This happened to be a 40B permit. The zoning permit was a 40B permit, but you're right, the analysis is different.
Yeah. Okay. So just returning to the issue of standing and ripeness for the moment, I think the standard for seeking certiorari review is that some alleged injury within the area of concern of the statutory regulatory scheme has to be reasonably likely. So that's for seeking certiorari. For seeking a permanent injunction against nuisance or trespass, the injury has to be reasonably imminent. Do you see a difference between reasonably likely and reasonably imminent? And to put the question another way, does the claims rise or fall together, or could it be possible that you have standing to bring certiorari, but that your claims for injunctive relief are not ripe or sufficiently developed yet?
I think they should be segregated, because I think the standing requirement that you cited is to count 1, which is the certiorari complaint. And actually, the judge, I believe, found that we had standing under count 1. And I think that's a less rigorous standard, certainly, than the count 2. So I think you could...
Something could be likely without being imminent.
Of course, yeah. So you could rule that we have standing on count 1 and reverse the permit, but not give us the relief under 2 and 3.
Okay.
But again, on 2 and 3, I don't know what more, on a Rule 12 motion, this isn't summary judgment, and we didn't even get to trial. On a Rule 12 motion, I don't know what more we could have done in the complaint to allege the imminency of the danger, where we had a hydrologist do a model that's state-sanctioned, a mass balance analysis.
I suppose what more you could have done is talk about how soon the injury would happen, how imminent it is. You have alleged facts which might support a conclusion that some injury is likely. Obviously the defendants take issue with those facts and whether the mass balance analysis is relevant, but you haven't really alleged that an injury is imminent, have you?
Well, we do. We say we meet the standard under the case law that there's no contingent events and there's no uncertainties. Whether it's imminent or not really is under their control, not ours. The developer controls when they put the shovel in the ground and build the house and move people in. We don't control that. That could happen in a month. It could happen in 2 years.
I want to ask a question about what they might do and what issues are under their control that goes to the issue of the 4-foot separation requirement. As I look at the plans and the record, it appears that in order to reach the 4-foot separation requirement, they're going to need to add some fill on top of the existing grade. Is that correct? I mean, they say that the groundwater currently is at a depth of 3 feet. In most of the test pits, I think in one of them it was 3 feet 4 inches. But to get to 4 feet, they're going to need to add fill.
I don't know if that's in the record, Your Honor.
Well, if we look at the plans that you attached in your addendum to your brief, there's a diagram in the lower left corner. This is page 184 of your addendum. It's a cross-section of the top of the hill where the leaching field will be sited, and there's a curved dotted line that appears to represent the existing grade, and then there's a straight line that represents the estimated seasonal high water table, and then there's another straight line above it, 4 feet above it, that says proposed grade.
Correct.
So I infer from that that they're going to have to add some fill on top of that dotted line to create the 4 feet of separation. If they go in there and they find, lo and behold, the water table is actually 2 feet and 9 inches below grade rather than 3 feet, can they just add another 3 inches of fill on top of what they were planning to bring this up to the 4-foot separation requirement?
I mean, that's an engineering question, Your Honor. I don't think I'm competent to answer that.
But it's a contingent event that you would agree would perhaps affect whether the excess nitrogen is going to reach your client's wells.
No, because the separation requirement's completely independent from the nitrogen loading requirement.
But wouldn't more separation, I'm not an engineer either, but wouldn't more separation tend to suggest that less nitrogen is going to escape the field and migrate down gradient?
Not necessarily. It's the issue with when Mr. Horsley, our expert, did the mass balance analysis, he assumed that the project would be built in compliance with Title V, and there's no variable in terms of the separation in that model. They just take 35 milligrams per liter of nitrogen at the source, and then measure how it goes from the pollution source down the hill. With respect, that he adds a variable for natural recharge of rainwater. It doesn't have, the vertical separation really doesn't come into play on that issue.
Okay. I want to ask about the...
No, can I just playing off of that point, so this would seem to go back to your earlier argument that you think the Title V regs are just not strict enough, because if it's in compliance with the Title V regs from a design point of view, and it's still causing a nitrogen problem on a well more than 100 feet away, then you're just saying, well, Title V is not strict enough. Is that a fair?
Well, I think it's an alternative argument, Your Honor. I would argue that Title V needs to be interpreted so that you would apply the 10 milligram per liter standard to an abutting well.
Even though if you look at Title V, there's no regulation that says thou shalt not cause a violation of the drinking water.
Exactly.
standards.
One further question about the mass balance analysis. As I understand the guidelines, it applies to evaluate systems from 2,000 to 10,000 gallons per day, in which the applicant proposes to aggregate facility land and non-facility land to say, as an average matter over this larger area, the nitrogen reaching either nitrogen-sensitive areas or sensitive points is going to be less than 10 milligrams a liter. So 2,000 gallons per day or more, aggregated facility and non-facility land. Why should the board assume, why should we assume, that the mass balance analysis can be applied to this case where we're looking at 550 gallons per day and we're not doing any aggregating?
So that the mass balance analysis is an equation that's referenced in the nitrogen loading guidelines. That is true. And the nitrogen loading guidelines only strictly apply to certain circumstances, which, as you described, are nitrogen-sensitive areas.
So we understand your concession that they don't, by their own terms, apply.
Well, it's not that they don't apply. It's just that they are referenced in that section, but that doesn't necessarily mean that you can't apply a common generic model
Okay.
to evaluate a different set of circumstances.
But how do we know that that common generic model of a mass balance analysis is applicable to a system like this that has only a quarter of the flow of what mass balance analysis is applied to in the guidelines, and also doesn't involve any aggregation? It involves a relatively small area. And I think one of the critiques of the mass balance analysis was that the area of impact had been underestimated. How should we conclude, or how can the board conclude, that mass balance analysis is necessarily applicable given those differences?
Well, our expert said so, so it's a credibility issue. Our expert testified to the Board of Health, provided an affidavit in this case in the Superior Court.
But if it's a credibility issue, you lose, don't you, on the certiorari appeal?
I don't think so. I mean, I think that the standard is substantial evidence, and we had evidence in front of the Board of Health showing this impact on the well. All the modeling that Mr. Horsley did.
I'm talking about the Title V counts, not the nuisance.
But even in Title V, it's still substantial evidence, and we had this evidence in the record before the Board of Health at that time.
Okay, unless Judge Sachs has any more questions, I'm afraid your time is up.
Great. Thank you.
We will hear first from the town of Stowe, and then from Habitat for Humanity. I understand you're splitting your time 10 and 5. That's
Sure, unless the justices have more questions regarding the nuisance and the trespass, then Habitat would answer those, but I could also answer them.
okay. The clock should be 10. Yes, thank you.
Thank you.
Counsel.
May it please the court, my name is Amy Quessel. I represent the town of Stowe. And just to play off some of the questions that have already been asked, there's a substantial issue here, which is the fact that when this mass balance analysis was done, the groundwater, the direction of the groundwater has never been confirmed. There were too many unknowns in this. First of all, a system this size does not require such an analysis.
We've got that, and he's conceded that.
Yes.
But there's nothing that would prevent the board from applying it, is there?
There's nothing that would, Your Honor. However, I think that the numbers would have to be adjusted based on the small size of the system.
Can we find anything in the record that supports that assertion?
No, and I don't think there's anything in the record that actually that mass balance analysis was configured to this exact system.
Is the actual equation anywhere in the record?
I'm sorry, I didn't hear you.
The actual equation that opposing counsel referred to, that the mass balance analysis uses with area of impact and impervious area and those other numbers that we saw on Mr. Horsley's chart?
No, it was just the chart that I am aware of in the record. Furthermore, with regard to plaintiff's expert, plaintiff did have an expert. He submitted evidence. He submitted a chart. He submitted a PowerPoint. However, the town also relied on 3 experts. So the town had the Neshoba Valley health agent. The town had a third-party reviewer that came in, and the town also had the engineer for Habitat. All 3 of those experts took the plaintiff's evidence, looked at it, and critiqued it, and evaluated it, and said whether it applies, whether it doesn't apply. The Board of Health, then took that evidence in, and they weighed appropriately what their decision was weighed on all of the evidence before them. So I would have to agree with Justice Milkey that if it comes down to that, the board wins. The board was reasonable. They took in substantial evidence that was before them. They made a decision, and the decision was correct. They did not base their decision off of a newspaper article. They relied on experts when they made their decision. With regard to the system itself, it's undeniable that the system meets Title V. And therefore, that's where we start from. The system meets Title V.
Well, you say it's undeniable. The plaintiffs contend that the 4-foot separation requirement isn't met.
So the 4-foot separation is met. It's shown in the logs. It is shown, and
Does that depend, by the way, on adding fill?
not necessarily. So
At the top, right above the leaching field.
right. So what happens is right now, if you put on my glasses. I'm sorry. On RA 219, it's a February 28th, 2020 letter from the third-party reviewer who states that test pit number 5, which is one of the test pits that the plaintiffs relied upon, it states that a 1-foot A horizon, 1.5 foot B horizon, and a 3.5 foot C horizon for an overall depth of 6 feet. So there's naturally occurring 6 feet, but the A layer comes off. The A layer is topsoil. And so the B layer usually also comes off. They are going to replace that with proper septic sand. And that letter further goes on to say that the C layer is left alone.
Okay, but then his conclusion there is that there's a 4-foot depth of naturally occurring pervious soil.
Right.
That's a separate requirement, as I understand it. It doesn't have anything to do with where the water table is.
Right. There is a
Okay.
yes.
Okay, so we're talking about whether there's 4 feet of separation between the bottom of the perco pipes, whatever they are,
Percolate?
and the water table.
Yes,
the
and that-
season high.
Correct, and that is what's
So this
happening.
doesn't address that.
Well, that is what's happening here. That is in the record, that the Percolate tubes will be over 4 feet from the estimated high groundwater.
And does that depend on adding fill?
All septic systems depend on adding fill because you add septic sand.
I'm
so
sorry, I
yes.
should say adding fill above the current grade. So that the,
Not if you include the A layer. No, I don't think so, because in the test pits, they don't, the 3 feet that you referenced earlier, that doesn't include the existing A layer. So they will be adding soil.
where do we find that in the record, that the 3 feet does not include the A layer?
Well, it says it in page 219, where it says that the C layer remains, and then they add the septic sand. But yes, in any event, I guess to stop any confusion, in any event, if they do have to add, they can add soil or material, I would say, because it's septic sand. So they can add that to create the 4 feet.
Okay,
And
so
then
if
they rest the tubes on top.
All right, so if they start construction and they dig down 6 inches and there's the water,
Yep.
theoretically, they could add,
Exactly, and those are, if you're driving by and you see weird mounded, those are what they call them, mounded septic systems. But that's another way to do it.
yeah. Just as a housekeeping matter, may I ask, the version of the plans that's in the record appendix is somewhat blurry, and the plaintiffs have supplied, in an addendum to their brief, a slightly older version of the plans, but that's much clearer. It's at addendum page 184. Do you have any problem with our relying on that?
I do not. I agree with plaintiff that the changes are not pertinent to this argument.
Okay. Can I ask about standing?
Yes.
For certiorari, would you agree that to establish standing to bring a cert claim, they only need to allege that it's reasonably likely, or perhaps show that it's reasonably likely that they'll suffer some injury if the permit issues?
They have to show that it's reasonably likely. Yes, I would agree with that, and I would say in this instance, they cannot do that. They cannot, in this instance, they cannot show that it's reasonably likely because of the fact that there is evidence to the contrary. The fact that the system meets Title V, the fact that there are 3 other experts that state that this system can be built, it's in accordance with Title V, and therefore issuing a Title V permit was reasonable.
Well, just because issuing the permit was reasonable, or if it was, doesn't necessarily mean that they won't suffer an injury. I mean, as was discussed before, we're not aware of any provision in Title V that says you can't pollute your neighbor's wells.
Well, that's the purpose of Title V, is for the health and safety.
That's the purpose of it,
Yes.
but the grant of a permit is not a guarantee against it.
No, it's not. However, if there were, I would assume if there were some kind of contamination, then the system, there's something wrong with the system, because the way that the system is designed, there is a stamped plan from a professional engineer attesting that this system meets Title V.
Okay, so the plaintiffs contend that it doesn't meet Title V because there's not 4 feet of separation. Do we have to resolve that issue in the board's favor in order to conclude that the plaintiffs don't have standing? Because if they're right about that, then it doesn't comply with Title V. And why haven't they alleged at least some facts? Perhaps it's an incomplete mass balance analysis, but some numbers are there that shows that they're going to get more than 10 milligrams a liter at their wells.
But it's incomplete, and that's the whole point, is that the board could not rely upon an incomplete study.
Okay. So do we have to have a trial about whether they're right? I mean, they've alleged in their complaint, we had our expert do a mass balance analysis. He predicts that, or he concludes that we're going to have more than 10 milligrams a liter of nitrogen at our wells. Why shouldn't the court, in deciding whether the plaintiffs have standing, at least consider those allegations as true?
Because this is a certiorari action.
Okay. So then does the court have to find facts? I mean, how does certiorari, how does standing get determined in a certiorari case where the court's dealing with a closed record?
The standing has to be proven in the record. And that goes to the Higbee case, where the plaintiffs have to actually have to show that there will be likely harm.
So the standing has to be shown in the closed record?
Yes, it's a certiorari case.
But I'm confused. The judge here did not say they lack standing, correct?
Correct. Correct, Your Honor. So in any event, even if they did have standing, our position is that the permit was issued properly.
Okay.
Thank you very much. We'll hear from Habitat.
Good morning. If it pleases the court, David Bannard for Habitat for Humanity, North Central Massachusetts, Inc. Thank you. I think you've already heard an awful lot about the case, and you've heard the amount of review that this went through. I'd like to offer from the start that we too believe that the town acted properly and acted on substantial evidence that was presented to them. There's a presumption under Title V in 310 CMR 15003 that a system that meets Title V standards is protective of the public health. And so that is really the standard that we're working with. The board was presented with all the evidence, and they waited, they made their judgment, they had the evidence from the plaintiffs, they had the opportunity to hear from them, and they made a reasoned judgment. There is no question that they're...
Just for the record, you're not arguing straight preemption or that Title V occupies the field, that if after such a system were built, it is causing actual contamination, you seem to be conceding that they could at that point bring a nuisance.
I concede that. And in fact, the dismissal of the two common law claims was made without prejudice. So the plaintiffs, if they are ultimately damaged, which we believe is exceedingly unlikely, would have a right at law against Habitat and against the occupants.
So why wasn't the complaint, which pleaded that their expert had done an analysis and concluded that the project would cause nitrogen levels of above 10 milligrams a liter at their wells, why isn't that sufficient to establish that they can proceed with their nuisance and trespass claims?
I think that the nuisance and trespass claims are really a collateral attack on the Title V determination by the board, and it's an inappropriate way to try to overturn an appropriate administrative decision.
But it wouldn't overturn, if we were to affirm the permit, construction could theoretically go forward at the risk of, to Habitat for Humanity, that if the plaintiffs can later prove nuisance or trespass,
Exactly.
Whether we remand and reopen those claims or whether they have to bring a later case, that's at Habitat's risk.
Yes, I think
So
that's
why
exactly-
is it a collateral attack? It doesn't seem to have any effect
It's
on
an
the...
attempt to litigate this through the common law rather than litigate this through the Title V process.
But what's wrong with that if the common law exists to protect people like the plaintiffs, even if this system meets Title V requirements?
I think the issue here really is, as you say, if the system is found to, if certiorari is not found here, if the town's Board of Health ruling is upheld and Habitat goes ahead at its own risk, there are still rights and remedies for the plaintiffs in this case. And that's really the kind of key issue here.
So why can't they pursue those remedies now? Why wasn't it premature to dismiss the nuisance and trespass claims?
There is really no real value to that other than exceeding, I should say, adding to the time that this case has gone on. I mean, as you've seen from the record.
Why would pursuing those claims necessarily stop the project from going forward? It would certainly create a dark cloud, but unless they manage to obtain a preliminary injunction against construction, the project can go forward. The same way it could if we affirmed the dismissal of those claims, but you know that they can bring those, it was without prejudice, so they could bring new claims anytime they wanted.
I totally take your point, but I think the issue here is that the plaintiffs would like to have discovery as they've asked for. They would like to go have a full trial. We're going to talk about, ending up with a long period of time. I'm quite sure they would move for an injunctive motion. If I were in the plaintiff's shoes, that's exactly what I'd do to try to stop it.
Well, preliminary injunction is to preserve the status quo pending a final judgment because the otherwise irreparable harm would occur. And there's a balancing, of
Yes,
likelihood of success. They're not guaranteed to get a preliminary injunction, are they?
No, they're not guaranteed a preliminary injunction. In fact, one would think that presumably the grant of the Title V permit, if it's not overruled by this court, would in fact make it rather unlikely that a preliminary injunction would be granted. But we're going to be back in court. We're going to be spending more time when we would really like to be under construction and building 2 units of safe, decent, and affordable housing.
Counsel, thank you very much.
Thank you very much.
The case is submitted. I just want to say it was extremely well argued by all 3 counsel. This concludes our session today. Our thanks to the court officers and the clerk's office and our own law clerks for making this hearing happen. We are adjourned.
All right.